Good morning, everybody. Welcome to an oral argument session at the 5th District Court of Appeal. My name is Dan Traver. I'm joined on the panel today by my colleague, Judge Randall Wallace. And we're also joined by an associate judge today, the Honorable Lisa Munyon, who serves in the 9th Judicial Circuit and sits currently in the Orlando Division. Everybody's streaming live on YouTube. This is the case 19-3344, Samuel Hawanski versus Ernest Watts and Corey Nelson. Each side will have 20 minutes. I will assume, unless you tell me differently, Mr. Gorowitz, that you would like to reserve 5 minutes for rebuttal, but feel free to tell me a different time if you would like. And sir, you may proceed.
Thank you, Your Honor. May it please the court, and yes, Your Honor, 5 minutes will be fine. Your Honors, this, I believe, is a relatively straightforward case. It's a de novo review about what the law is in this case and whether Judge Earp correctly interpreted the statute or not. The issue is basically, what does 489.1037(7) mean? If a homeowner hires an unlicensed contractor, can the homeowner be potentially liable for injuries to the unlicensed contractor's workers? And the answer...
Mr. Gorowitz, I have a question before we get into the weeds on 1037. Okay. In looking at your third amended complaint, it looks as if all of your allegations are based upon violations of Chapter 489.
Correct.
Am I right about that?
Yes, you are, Your Honor.
And
any common law cause of action here.
And 489.131 sub 12 specifically says, unless specifically provided, the provisions of this part shall not be construed to create a civil cause of action. Understanding that that is a pretty clear directive, do the sections of Chapter 489 that you allege have been violated specifically provide that a civil cause of action is created?
I do believe they do, Your Honor, but let me go back to 489.131. If you take a look at the applicability, number one, this part applies to all contractors, including but not limited to, etc. When you read the provisions of this statute, it's obviously talking about licensed contractors. It's not talking about homeowners who are deemed contractors under 489.1037. And 489.1037 is specifically exempted from the other parts of Part 1 of Chapter 489. So it is our contention that 489.131 is not even applicable to 489.107 because it is exempted. But even if it was not exempted, it's pretty hard to read that disclosure statement and not conclude that the legislature's intent, as reflected by Murphy, specifically allowed for a private cause of action against a homeowner who hires an unlicensed contractor, because it says so throughout the disclosure statement repeatedly, and there's no other possible way to interpret 103 other than saying, yes, there is a private cause of action. So our contention is very simple. 489.131 is not applicable because it is exempt, or 1037 is exempt from that part of the statute. But if it's not, it still does specifically in the disclosure statement repeatedly make clear specifically that there is a cause of action.
Okay, thank you. You can continue with your argument.
It's Mr. Gorowitz. My question is, you said homeowner acting as a subcontractor. What were the facts in this case that would justify categorizing or labeling the appellee in this case as a homeowner acting as a subcontractor?
Well, the homeowner contracted with another contractor who did not have a license. We conceded, we made that clear in our complaint, that the homeowner did not intend to do any of the work, did not do any of the supervision, but because he elected to not retain a subcontractor who had a license and was legally qualified to be a subcontractor, he basically illegally hired an unlicensed worker. And because he hired an unlicensed worker, the statute says he is a contractor for purposes of potential liability. So no, did he actively work as a contractor? He did not. And if he did, then 49.103 would not even be necessary, because then he would be liable under the common law. If he undertook a duty and violated that duty, we wouldn't need the statutory obligation, duty against him. The statute, though, itself, regardless of what he intended to do or what he did do or did not do, creates the duty. And again, we would argue that that is perfectly clear in the statute itself.
So the argument is, if I understand correctly, is that if he had properly hired a contractor, the contractor could not be sued because of the preclusion of any private right of action in 131. But because he didn't hire a contractor, we're going to assume he was a contractor and thus allow him to be sued?
Well, no, I'm not saying that if he had hired a contractor, there could be no suit. Because
why not? Doesn't 131 specifically say that? I understood, and correct me if I'm wrong, I understood your response to Judge Munyon to be along the lines of, well, that section only applies to contractors. But what we're dealing with in this case, because it's not a contractor, it's somebody implied to be a contractor, then we can therefore also imply a private right of action.
You can not necessarily imply a private right of action. I think that the statute specifically explicitly provides the cause of action.
But you agree with my initial premise that if this person, Mr. Nelson, was a licensed contractor, then he could not be sued under this particular statute because there's no private right of action against contractors.
Well, you mean, could Mr. Watts be sued?
No, I'm asking about the actual, if Mr. Watts had done exactly what you say that he should have done and hired a licensed contractor,
he could not,
and the same thing would have happened. You can't sue either of those guys, the licensed contractor or the homeowner, under this particular statute. You might have other ways that you might be able to sue them, but the statute specifically precludes any private right of action against a contractor. Fair?
Well, again, you're not. I think that under the statute there's the exemption, so I don't think 131 is applicable to begin with.
Right, and I'm just trying to see if I can get you to agree that if it was an actual licensed contractor, then 131 would apply.
If he hired an actual licensed contractor, I don't think there's anything in 131 that says that a licensed contractor who is negligent could not be sued, because under the common law,
right, he just could, and that was my point. He might be able to be sued for some common law, under some common law theory. I'm just asking you, he wouldn't be able to be sued under the statute, correct? Well,
there'd be no necessity of suing the active contractor under the statute, because the common law would be applicable under that circumstance. So the statute is only, the statute creates certain causes of action that would not otherwise be there because there is no common law cause of action. And we concede.
What cause of action does the statute create? Where? Other than the one that you're implying in 107.
The duty created in this case is a homeowner hiring an unlicensed contract to improve his home or to do building or construction on his home. And the statute specifically creates the duty and says you cannot hire the unlicensed contractor. And if you do so, you are on the hook for, or you are potentially on the hook for injuries to unlicensed workers, and or for injuries to employees of the unlicensed contractor. And this makes perfect sense, Your Honor. This completes the circle. You know, throughout the statute, it makes it clear that the unlicensed contractor can't collect on his contract. He can be criminally prosecuted. But the argument by the defense is there's a huge hole in there. There's a remedy against the unlicensed contractor by law, criminal penalties, on inability to enforce his contract, but there's nothing against the homeowner. There's nothing, if there's no remedy against the homeowner who hires an unlicensed contractor, well, there's nothing to stop the unlicensed contractor from doing whatever they want, from doing what they did in this case, not providing workers' compensation, not providing competent supervision, and the homeowner gets off scot-free. And that is not the purpose of 489. 489 is for safety of the public. 489 is for safety for people like Mr. Hawansky, who was hired to help an unlicensed contractor without knowledge that there was no insurance, and then got very seriously injured. He lost his eye. And all we are saying is this statute, 489-103, closes the circle and not only puts an obligation on the negligent contractor, unlicensed contractor, in this case, Mr. Nelson, but puts liability on the homeowner, the duty on the homeowner for putting this whole thing into play to begin with. If the homeowner is not hiring a licensed contractor, these type of things won't happen. Licensed contractors are much more likely to comply with the law. They're required to have workers' compensation insurance for one or more employees. They're required to have some kind of qualifications and competence for the job, or else they don't get the license.
I mean, it sounds like you're making a public policy argument.
Well, I'm making the public policy argument because I think the public policy argument is the reason why this statute exists as it does. I think the legislature—
Is there a competing public policy argument as to why the legislature may have decided in its judgment not to require every homeowner to hire a licensed contractor when they need a fence repaired?
Well, in this case, the entire fence was basically replaced. Clearly, they needed a permit. There's some indication under this statute for, I believe under number 9, that for smaller job or very small jobs, inconsequential jobs, that maybe it would not be applicable. But I think the clear intent of the legislative intent here is clearly to say, hey, look, Mr. Homeowner, we have laws in this state. You're not supposed to hire unlicensed contractors. And if you do, you may be liable. We are imposing a duty on you legally under statute so that you don't go about hiring unlicensed contractors. You know, in the world of the internet, anybody can get on the internet and determine whether somebody has a valid license or not, whether the number that they're provided, if they're provided a number, is valid or not. So I am making a public policy argument, but I understand public policy itself is not enough. There has to be legislative intent.
I've got a very brief question. I don't want to take a lot of your time. You mentioned that he hired the contractor for improvements on his home. Your complaint actually says it was for fence replacement or repair. Clearly, fence replacement or repair could require a permit, but does that fall within the definition of contractor under 489 at all?
Well, sure it does. It's construction on the property. If it's not the home, doesn't say the home, it says the property. There's been improvement to the property of the homeowner. Doesn't necessarily have to be inside the home. Doesn't have to be in the garage. It's part of the property of the homeowner. He's hiring, and clearly, I mean, there are plenty of fence installing companies, and they're all licensed, and they come out and this was not a small job. This was we did take the depositions. I know they're not in the record because they have not been transcribed.
Well, then let me stop you there. I think the concern that I'm having, Mr. Gorowitz, is that you're asking us to make a public policy determination as it relates to a statute. And while we might have a public policy role as it relates to certain common law issues, are we really the best branch to decide what the public policy should be out of a statutory scheme?
Your Honor, with all due respect, I'm not asking you to make a public policy decision. I'm simply saying that public policy is probably what derived the purpose of writing this statute. That's the purpose of the legislative intent of creating the duty in this statute for hiring the unlicensed homeowner. I'm not asking the court to say as a public policy that homeowners are not liable for unlicensed contractors. I'm saying the public policy is the reason why the legislature probably did what they did. I'm asking the court to look at the legislative intent as by the words of the statute and interpret the statute to mean what it says.
All right, you're into your rebuttal time. Do you have anything further?
Thank you, Your Honors. I appreciate the time.
Mr. Brownlee?
May it please the court, Mike Brownlee here on behalf of the appellee, Ernest Watts. I think Your Honors are on the right track. I think Mr. Gorowitz's position would be well taken if he was on the floor of the legislature or lobbying the legislature, and he may very well have some good ideas about better policy measures that could be grafted into the statute. But fact is, 49.131 subsection 12 very specifically says there's no private right of cause of action here. And I think at the beginning of his argument, Mr. Gorowitz made a couple references to saying that somehow subsection 103.7 was exempt from that. It's 100% not. I mean, 131.12 says, as to this part 1, there's nothing should be construed to create a private cause of action. 49.103 subsection 7 is within part 1. So, I mean, I think that's the long and short of it. I think it does amount to a public policy argument. I don't know how the court could adopt his position without directly contradicting the plain language of the statute. And with that, I'm inclined to rest on the briefs unless the court has any more specific questions.
Mr. Gorowitz, your rebuttal.
Well, Your Honor, again, 131 applies to licensed contractors. All the parts refer to licensed contractors. It's not even contemplating a homeowner who is deemed a contractor for purposes of a legal duty. And if what is the whole purpose of the disclosure statement, which is the law? It is considered the law. It is designated as reflecting the law in 107 itself. What is the whole purpose of that disclosure statement if there's no remedy? How else can the homeowner be potentially financially liable to an injured worker if there's no private cause of action? The disclosure statement has it doesn't even make sense if there's no cause of action or there's no duty. I think you understand, Your Honors, what my position is. And with that, I really have nothing else to add unless the court has some questions for me.
All right, thank you. Appreciate the arguments, and we will be in recess.
Thank you, Your Honor.
Thanks, Honors.